խոսքը փոխանցենք պարոն Մեջլեսսին ներկայացնելու գոհացած ակտիվների վերադարձման միջազգային փորձը եւ գործիքակազմը։
Բարև շնորհակալություն ավերի համար ես հայերեն չեմ խոսում, so I'll continue in English. It's a great pleasure and honor to be back in beautiful Yerevan and join you all on this very interesting time and on this important occasion for this conference, covering a wide range of anti-corruption issues, including some which I saw were heatedly debated in the morning, as well as the asset recovery that we are touching upon this afternoon. What I would like to do in my time is to focus on three issues in relation to asset recovery. The first one, to just have a global overview of where we are today in the area of asset recovery around the globe. Second, to focus on the asset recovery process itself. What are the different legal avenues for asset recovery beyond the traditional ones which are used in countries? And third, since we are looking at having some recommendations for the strategy that's being drafted, focus on challenges and solutions, and at the end some very concrete, perhaps, suggestions for this group to consider. In terms of where we are, I think the focus on asset recovery, on focusing on proceeds of crime, is a relatively recent phenomenon in many countries. Not only in Armenia, but globally, for a very long time, focus was mostly in criminal issues on culprits of crimes, and it's more recent to kind of turn that focus towards also proceeds of crime and going after those proceeds. There are very good reasons for that. I don't need to go over those, and I think the fact that you have started in Armenia to think more seriously about this is an evidence of the fact that the importance is already recognized here. But there are different reasons: development reasons, rule of law reasons, and basic policy reasons to focus on not only culprits of crimes, but also on decision makers and beneficiaries, particularly of financial and economic crimes, where the main motive and incentive of the crime is financial gain. So that's where you really had to hit them harder, follow the money, and get it back, particularly in cases of corruption where the money has been taken from the public coffers. Now, to give you an overview of how we are doing globally, this is a bit of an older study that we did, our initiative, which is a joint initiative between the World Bank and the United Nations Office on Drugs and Crime, did in 2014. At that time, we found that from an estimate of around $20 to $40 billion, which was estimated to be taken away through corruption from particularly African countries each year, we found that during a 6-year period between 2006 to 2012, only around 2.6 billion were frozen in other jurisdictions. And most of that amount, as you can see here, was frozen in only 4 jurisdictions: in Switzerland, US, UK, and Luxembourg. Again, this is a bit old, but it's the latest kind of figure that we had, and a study that we're really hoping to update soon. But nonetheless, as I said, 20 to 40 billion each year taken only from African countries, estimated, and around 2.6 billion frozen, not returned, frozen. Now, when we are looking at the return assets, it's even much less. From that amount, only around 423 million was actually returned to countries where it was taken from. Again, during 6-year period, And most of this came again from 3 jurisdictions, UK, US, and Switzerland. Since then, since that time, a lot has happened. So there is a huge gap in between the amount which is taken, the amount which is frozen, and the amount which is already finally returned to countries. And a common trend that we see, of course, in countries, and I think you may have also witnessed this in Armenia, is that there is a reverse kind of relationship between the amount which is reported or kind of speculations about the amount which is taken and what is finally returned. It's a huge kind of difference in between, you know, what the allegations are at the beginning and eventually what countries manage to freeze, confiscate, and eventually repatriate. But having said that, during the past, I would say, almost 30 years, where there is more global focus on asset recovery, more or less, starting very importantly with the case of Ferdinand Marcos in the Philippines in mid-1980s, and from 1986, we have a very mixed picture of success, failures, lengthy processes, but the optimist in me would say overall we have seen progress. Again, if we start in 86, since then we have around $860 million returned in the Philippines, but that's out of around $5 to $10 billion of estimated to be taken out by Ferdinand Marcos, the former president of the Philippines. In a neighboring country, with Suharto in Indonesia, there was less success. Another famous case was Sani Abacha in Nigeria, where again, the estimates were in billions of dollars, which were taken by him during 1990s. But since 1998, around $1 billion is returned. And only last December, in December 2017, a year, actually 2 years ago almost, a year and a half ago, in an event that we organized, $321 million was returned from Switzerland to Nigeria. This was a big success. But the reason that I'm highlighting this is to tell you that this case started in 1998 and the return happened in 2017. So, just to give a bit of perspective. It is a good news, but it took a very long time to have that good news. We all remember the Arab Spring a few years ago. It led to similar speculations about huge amounts of money which were taken out of several countries in the Middle East, Egypt, Tunisia, Libya, and so on. And again, the record of these countries is very mixed. There were cases that didn't work that well, and there were the ones that worked better, notably in Tunisia, where they had some success with $28 million from Lebanon, some $60 million from Switzerland, a number of luxury boats, yachts, planes, and so on, coming back from Italy, Switzerland, France, and so on. And there were cases that countries themselves didn't go after the assets, but the receiving countries were forced in a way to take action. The picture here is from a residence that belongs, or used to belong, to the son of the current president of the Equatorial Guinea, where the current government obviously wouldn't take action. However, civil society organizations in France brought a case to the court, which led to confiscation of assets, at least freezing, actually not yet full confiscation, in France. And again, major cases in less developed countries, in Afghanistan, in Malaysia, very interesting, it was referred to a couple of times this morning by Anga, were made famous 1MDB case where around $1 billion is already, more than $1 billion is frozen in the US, but this was an unusual case in terms of the speed with which things have happened so far, which may give a bit of a sense of more optimistic kind of view of what's happening. Closer to this region, in the past couple of months, there has been news of use of unexplained wealth orders in UK, leading to freezing of assets belonging to a businessman from Azerbaijan, also the son of the former Prime Minister of Moldova, who had a very kind of luxury lifestyle in London, as well as the case of Uzbekistan, the daughter of the former president, who now has an ongoing criminal case also in the US for around $865 million of bribe payments. My point about this picture is that it's very mixed. There are cases that nothing has happened, there are cases that very quickly things have happened, and there are cases that have taken very, very long time. And I think that would lead me to the second point, on focusing a bit on asset recovery process, and eventually on what makes or breaks some of these cases. Now, in terms of the process, I think it's important to demystify a bit the whole issue of asset recovery and how it works. Traditionally, the focus is mostly on criminal confiscation. This is a mechanism which is available in most countries, including in Armenia. However, I think it's important to be aware of the other channels which are available. What I'm trying to show here is that there are two basic kind of two ways of going about, two main kind of ways of going after stolen assets. One is following it in the domestic jurisdiction and then trying to enforce a domestic court order in another jurisdiction. And the second one, which is used a bit less perhaps, is to go in the foreign jurisdiction and start a case there. So that's what I'm trying to show here. In the domestic through the domestic channel, again, there are a number of legal avenues, a number of options available. Criminal prosecution, as I said, is the traditional one. It involves all the steps in a process of a criminal case, in this case related to asset gathering evidence, tracing and securing the assets, prosecution, eventually getting a conviction, and finally a confiscation order, and then trying to enforce that order to mutual legal assistance process, or MLA, particularly for the interpreter. Since I'm going to repeat MLA, I mean the mutual legal assistance process, to try to enforce through MLA. Of course, in the process, there are many steps that country would require MLA assistance, mutual legal assistance from other countries. The other channels which are kind of becoming gradually more common are non-conviction based confiscation, private civil action, and administrative action. I'm not going to spend a lot of time on all of these because we could go on for another day getting into details of these, but nonetheless, I think it's important to quickly mention that there are options beyond or apart from criminal confiscation if the law of the country permits that, if that is within the legislation of the country. And that's something to consider in your discussions related to an anti-corruption strategy and on asset recovery kind of avenues which are available, including non-conviction based forfeiture, which focuses not on the individual who committed the crime, but on showing that the property that you want to confiscate is a proceed of a crime. So a case is brought against an asset, not against a person. it sounds very strange and unusual to many lawyers with a more kind of thinking in more traditional terms about these processes, but it's something that has worked in many countries, including in the US. The $1 billion freezing that I was talking about on Malaysian case 1MDB is through a non-confiscation based forfeiture. There is also private civil action, which is very important, which should not be confused with civil forfeiture, which is the other name of the non-conviction based forfeiture. I hope I'm not confusing everyone with mixing these words. So there is non-conviction based, focusing on property or assets, but also civil action, going after damages, or going after showing the ownership of assets, basically going after an entity for a contractual breach. If it's an entity which has committed corruption, there are different ways of also going after them for proceeds of those corruption apart from a criminal case against them, which can lead to the same result. So these are, I think, important additional avenues that should be considered for any country that wants to go after proceeds of crime or corruption. As I said, when you are talking about asset recovery cases, typically on international cases, at every stage, at every step, there will be another jurisdiction or several jurisdictions involved. When you want to gather evidence, when you want to seize the assets and eventually return them, typically there are more than 1, 2, 3 other jurisdictions involved, where the money is laundered, where the assets are located, where different companies are registered that have ownership of those assets and so on. So all of this adds to the complexity of these cases. And again, I'm saying this because I know when these things happen, countries, the public expects everything to happen yesterday, while in reality, you have to deal with several layers of different jurisdictions in order to get to those assets. Again, I assume that you have experienced some of these challenges already, also in Armenia. And finally, as I mentioned, another channel altogether is to go to the court of another country and start a prosecution based on their jurisdiction over a case. So for instance, if the money is taken outside and is invested in another country, there is also an offense of money laundering in that country. So one way of going after assets is to find a criminal prosecution or non-conviction based process that would allow your country to bring a claim in the courts of another country, or to have a civil action in another country. Now, having said all of this, all of these different tools, all of these different legal avenues are also foreseen in the UN Convention Against Corruption, which was mentioned several times, which covers the issue of asset recovery from different dimensions. It has some elements related to prevention of money laundering. It has elements related to confiscation and freezing. It has many provisions related to international cooperation, which was mentioned also in the presentation from the Prosecutor General's office. And then it has a whole chapter on asset recovery, which is a fundamental principle of this convention. So it's supposed to make things easier, but I have to say it still has to really deliver its promise as an international kind of tool. Now, the third point that I wanted to bring up is challenges and solutions. I'm sorry, I'm going a bit over time, but it's such an extensive subject that it's impossible to cover in a very quick session. So I won't go through all of this. The major challenges that countries have faced, we looked at many different countries. We talked to many experts a couple of years back again and tried to understand what are the typical problems that countries are facing. And we grouped them through a study under 4 kind of headings here. One is lack of asset recovery policy. The second one is legal impediments, meaning not having sufficient legal resources or avenues available for this. Institutional operational limitations, and finally communication and trust between different jurisdictions and sometimes even domestically between different entities within a country. Each of these, you could go on talking about it in more detail, starting with lack of, what does it mean if you don't have the real political will or policy focus on this? It means that you won't give enough resources, or you won't kind of put enough emphasis on that area to develop the capacity, or you won't arrange the coordination mechanisms which are needed, and so on. The legal impediments, again, having all those different legal avenues available in the country, not having adequate tracing or freezing powers for law enforcement entities, not having value-based confiscation in the law, which would really limit the range of confiscation that can be done, not using UNCAC, the convention, effectively as a basis for international cooperation, and so on. Institutional ones, again, issues related to capacity, coordination, not having specialized or dedicated skills or units to work on this. And a very important one, finally, is communication and trust for countries in different jurisdictions to be able to deliver on kind of returning assets. It's really important to build a relationship of trust between law enforcement entities, between the kind of prosecutors, to help each other in the process. Now, what do you need to achieve that? All of this, which is a already complex picture, but it goes back to what I was saying. We try to map out, again, the process. I just want to highlight, because I'm not going to go through all of this, but I want to highlight the typical time frame for each of these steps. Again, you may not like what you're seeing here, but I think it's a bit of a reality check for everyone on how long does it take. A typical process from setting a case strategy to eventual return of assets can take up to 12 years or more. Now, should we give up because of that? No. What it means that we should start yesterday also in order to reach that 12-year mark as soon as feasible. Now, to get there, in order to get to that point, we need to put several elements in place in terms of political support, legal tools, institutional capacity, and operational capacity. What I will do, instead of going through this, I will share this with the organizers so that it can be looked at or taken into account in discussions related to the strategy. And solutions that came from our consultation with practitioners across the globe was along the same lines in addressing every single one of the challenges that we identified. And this is something that would translate then into some actions for your strategy. We need to provide practitioners with frameworks and tools, legal frameworks and capacity that they need. We need to build trusting relationships, not only domestically, but also internationally. We need to think outside the box. In these cases, for going after proceeds of corruption and corrupt officials, there are many, many new ways that people have found. You look always at where their children are studying. You look at where they go on vacations and so on, and finding ways of working with other jurisdictions to use their legal tools like unexplained wealth orders in UK to freeze assets and so on. Making better use of existing anti-money laundering tools. Very importantly, having political will, which will always lead to legal ways. Freezing, very important, before assets disappear. Something which is missed very often in these cases is that countries wait to finish a whole court process, and then after they want to go after assets. By that time, assets have disappeared completely, years have passed. Talking to your colleagues in other jurisdictions and being willing to help each other. I'm not going to talk about what we do. STAR, which was mentioned in the introduction, is a joint initiative between World Bank and UNODC. One thing that we do actually is country engagement. We work with countries that request assistance from STAR precisely to help them both with the capacity to do asset recovery, but also with facilitating international cooperation between countries so that they can actually help each other in bringing assets back. As I said, particularly when you have several jurisdictions involved. We also work on policy influence at the global level, and we work on creating networks of practitioners globally. And finally, we have a large number of tools, publications on asset recovery. I'm not going to go through all of this because I'm already well beyond my time, but what I want to highlight really is some of these knowledge products and publications, which are all available free on our website, sometimes translated into different languages. There is a database of cases, there is guide for practitioners, there are beneficial ownership guides, asset recovery guides from different countries that I really urge people who are interested to look at. I mean, the easiest way is to look at our website, which I have repeated on a number of these slides, and then, as I said, different studies. But my very, very last point is what are the key recommendations to consider for your purposes? And I would put 9 points here. I apologize to the moderator. I want to go over these 9 points and I finish. Looking at the 3 levels of policy, legislative framework, and institutional framework. First one, make asset recovery a policy priority, which means align resources to support those policies. In terms of legal frameworks, having preventive measures against proceeds of corruption, that was mentioned also earlier in the morning, setting up tools for rapid locating and freezing of assets, establishing a wide range of asset recovery mechanisms, which I mentioned earlier, like non-conviction-based proceeding and private law actions, and finally, adopting laws that encourage and facilitate international cooperation. That's at the legal. And at institutional level, an operational one, creating specialized asset recovery teams or task forces, where necessary, engaging in joint investigations with other countries, using the capacity of other countries to do investigations with you, or sometimes getting technical cooperation from entities like STAR itself. Participating actively in international cooperation networks, some of which was mentioned in the Prosecutor General's speech. And finally, collecting data on cases and sharing information on impact and outcomes for the purpose of strategy. And very, very last point, one thing that many countries miss when they start doing this is thinking about what will happen after assets are returned. I have seen so many cases of cars which are confiscated and are rusting away, properties, assets that have come back, and they haven't thought about management of those assets, so all those efforts will be in vain at the end. I went well beyond my time. I thank you for your patience, and շաչնոր հակալեմ.
Շնորհակալություն պարոն Մեջլեսի.